what's Plevin doing when he's doodling in class? You know, when he's doodling in class and not paying shit attention to what the teacher's saying, right? What's he doing? He's fantasizing. He's fantasizing of being like a John Wick kind of guy. Ooh, ooh, ooh. I'm taking on everybody. Pew, 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 pew.
John?
Stop it, Plevin. Stop it. Are you fucking kidding me, dude? The Turtle Boy phenomenon. So fucking ridiculous. Listen to these fucking idiots, dude. I don't think what Turtle Boy does is 90% bullshit.
It's 90% bullshit.
But Denzel in Training Day is a newspaper. It entertains me. It entertains me.
This is a newspaper, right? It's 90% bullshit, but it's entertaining.
I'm putting cases on all you bitches. Huh? You think you can do this shit? Jay! You think you can do this to me? You motherfuckers will be playing basketball in Pelican Bay when I get finished with you. Shoe program, nigga. I'm the man up in this piece. You'll never see the light of day. Who the fuck you think you fucking with? I'm the police. I run shit here. You just live here.
Natalie likes to talk to people.
What the truth is, you know, it's crazy.
I mean, I don't think she'd get mad at me.
Olivia Dial fucking kills me, bro. She likes to talk to people. Who the fuck else would she like to talk to other than people? Mark Wahlberg talks to animals.
And now Mark Wahlberg talks to animals.
Hey, I'm Mark Wahlberg. You guys know me. Yeah. Let's go talk to some animals.
Yo, I'm going to talk to a chicken. What's up, chicken?
Now I'm going to talk to a chicken. Hey, chicken, how's it hanging? Say hi to your mother for me, all right? Now I'm gonna talk to a donkey. Okay. Talk to you later, donkey.
Hey, yo, did you see Boogie Nights? Dude, nothing beats that scene, bro. Nothing beats the scene where Will Ferrell shoots himself with the dart.
Ow!
Yes, that's awesome.
Yes! That's awesome.
You got a fucking dart in your neck, man.
Got a fucking dart in your neck.
You should pull that out. That shit is not cool. Christ, what are these people talking about?
Guys, give us some feedback while we're doing this and get.
Stupid, worthless, no good, goddamn freeloading son of a bitch, retarded, big mouth, know-it-all asshole jerk.
Getting started and let us know that our mics are all on the same level.
Give you some feedback. Where the fuck do I start? I have no idea how many times I've said on this channel and said, at this point, if you think that Karen Reed is guilty, you are fucking retarded. Give us some feedback. Jesus Christ. It would take me a fucking month.
You forgot ugly, lazy, and disrespectful. Shut up, bitch! Go fix me a turkey pot pie.
Like if Court TV took a shit and Coffindoffer came out, like whatever was left on the toilet paper with that they wiped with is this lady. That's from the same turd. But
I mean, she's screwed. They can only do better, the Commonwealth, this time around.
Mm-hmm.
The dumbest people in the world are on the other side, the Plevins of the world.
Somebody clip that. Somebody clip that. What am I going to do without Plevinisms? Plevin, you complete me. Not really. You're, fucking retarded. Like, people had to remind me and be like, hey, when are you going to do Plevinisms again? And I'm just like, when I don't have anything else to talk about. Yeah. Nobody gives a fuck about you, Plevin. Not like that. Like, you serve the purpose that a fucking street clown does. I mean, Plevin, are you getting it? Are you getting it?
I'm retarded?
Good, and it's a big difference. On the Free Karen Reed side, if you consider yourself a decent person, you will spend 2 seconds looking into what Aiden Kearney does, and you will speak out against it. If you do not do that, you are not a decent person.
That is what you call willfully ignorant. And that is the definition in which that I have redefined the word retarded, because I'm keeping the word alive. I don't give a fuck what people say. I don't give a fuck what you fucking little politically correct fucking values and your delicate sensibilities are.
Well said, Kerry. Absolutely. And, I posted today on Twitter, I feel it's not even my district, but I do feel an appreciation for the work of Adam Wiley. And there were some things he did very well. And
oh my God, that is the darkest fucking super chat in the history of fucking super chats, bro. That's the darkest fucking super chat anybody's ever fucking gotten, bro. Like, oh my God, dude. I'm gonna go run and give $2 to the fucking Cancer Foundation right now, bro. Like, this should have worked. I was on Court TV night after night after night. I was on Court TV. This should have worked. This should have built my channel. What in the world happened? And it doesn't occur to him that he talks out of his ass and nobody fucking and nothing he says resonates with a single person who is capable of tying their shoes.
Joe Flipperhead.
That's all.
It's sort of like a $2 I'm gonna put Joe Flipperhead on this.
Flipper.
We enjoy.
Not gonna put it. Do you think I'm gonna put Joe Flipperhead on this?
Woo! Good afternoon, my friends. How are you? I'm doing well anyway. It's good to see you guys. Yeah, today don't expect to see all the usual friends that we have. I'm live because I have been meaning to go over this case for a while, both of these cases. There was a very brief Brian Walshe hearing that took place earlier. We're going to go over that later. And mostly because of the relevance that it has in the Karen Reed case. So we're gonna discuss that a little bit, but mostly we're here for Sarah Boone. Now, for those of you who don't know, Sarah Boone is the suitcase killer. She's the woman who now I know what it sounds like. For those of you who aren't familiar, okay, I know what it sounds like to you, that she killed somebody and then stuffed them in a suitcase, got rid of it. That's what first comes to mind, right? No, that's not what happened. What happened was This woman was allegedly playing hide and seek with her boyfriend, who she had apparently why can I say that word? Why can't I say that fucking word? Oh my god. I've always been able to say that word. Anyway, I can't say that word. I don't know why. I'm totally stuck on stupid right now. But anyway, I could read it. Hold on. Let me see if I can sound it out. Tumultuous. Okay. Anyway. So yeah. Anyway, you guys know what it means. So get him, Clever. Clever's trying to get a fly. Get him, Clever. So yeah. Anyway, their relationship was toxic. How's that? And they so she apparently talked him into going into a suitcase, but they were playing hide and seek. So how now they were drinking, so maybe they were playing hide and seek under drinking rules. I don't know. Whatever that is. But I guess under those drinking rules, when you're playing hide and seek, you actually tell the person that you're trying who's it. The person who's it tells the person who's hiding where to hide. And so apparently that's how that works. And then when they're locked in the suitcase and they can't get out, and say that they can't breathe, you pull out your phone and you film them, and then tell them that they're in there for all of the times that this person laid their hands on you or whatever, so on and so forth. So apparently those are the new rules of hide and seek, according to Sarah Boone. And what we're going to do, we're going to go over a hearing that's going to go on today. There's going to be certain statements, I think, that she's trying to have certain things removed. She's filed a motion to have certain things that the jury cannot hear. Now, I don't know how that's going to work out for her. Now, it makes sense to me that if she can file a motion to try to have things, suppressed from the jury, then cool, but it doesn't mean that she's going to get them. Now, here's the thing is, me personally, I think this woman is 100% guilty. I think she needs to at least be held accountable. Do I think that she maliciously thought that she was going to kill this man? No, but common sense should have dictated when he said that he couldn't breathe, that she shouldn't have just gone to bed and told, and said, good luck, pretty much. So that's, yeah. Now, the other very, very interesting fact about this case is, I believe, Sarah Boone's 9th attorney. After the 8th, I think it was, I'm pretty sure I got that number right. The judge was like, no more, you're done. She basically, in my opinion, trolled the justice system by just in order to stall. Made it impossible for her court-appointed attorneys to work with her, and so she would either fire them or they would recuse themselves. And so, yeah, he zipped himself in the suitcase, right? Okay. So, well, yeah, if you want to count herself. Okay, yeah. Okay, 9th, including her as pro se, right? And then Sarah Boone made an ad with all her little different. I mean, she wrote an ad and added all these different little pick monkey fonts. It was real cute. And somebody answered, apparently, and is now representing her. Now I figured that this case was going to be very interesting. This trial was going to be very interesting to watch if she was representing herself, which it would be. I think it's still going to be very interesting to watch, but with the fact that she was representing herself made it a little bit more interesting. But I'm kind of relieved that that's not happening, because I have trauma from Darrell Brooks representing himself. I felt so bad for that judge. And I feel like Sarah Boone is going to be just as difficult, probably better at trolling the entire trial. I find her personally so far to be very manipulative. And she's not helping her case at all. She could have just been like, it was an accident and that's it. But yeah, that's not what's happening here. Now, let's go ahead and pull this up here. I've got it ready to go. Now, some of you saw, I just wanted to pay tribute at the beginning of this to Joe Flipperhead. I really like Joe Flipperhead. He was messaging me and he was like, dude, listen, man, I was fucking dying. I was fucking dying at your live, and I'm in the middle of making like a compilation because shit had me dying. It was like I had to pull over the side of the road. So I was like, yeah, right on, go for it. And then he promised me that he made this other cut that was copyright, proof, which I don't think is going to happen. I think I'm totally going to get dinged for all of those movie clips that are in there, but that's worth it. It's totally okay. I'm not mad at nobody. But anyway, it was just fun. I just wanted to share that little Joe Flipperhead effort there, that little compilation. It's always an honor in this community. Well, at least in the Free Care and Read community, when Joe Flipperhead makes a compilation video on your shit. So I was really proud of that. She graduated high school on the honor roll. Well, I mean, stop the presses. I had no idea that she was on the honor roll in high school. It changes everything. Absolutely changes everything. No, man. Ron, I did not just wake up, my friend. I'm still kind of getting over a cold that I had on vacation. So yeah, I'm still gonna be a little hoarse, but the woos are getting easier each live that I do. So that's always a good sign. And I feel good too, because I'm back in my routine, going to the gym. And I went the last 2 days and I feel absolutely fantastic. Yeah. And I don't think we have enough time, but in regards to the Joe Flipperhead video, so Scott McGinnis was asking, Scott McGinnis was saying, will the Glairer debate Plevin? No, there is no debate. There is no debate. I learned my lesson with bitch Tim. Now, I debated on whether or not I was going to just let him up here, because there was no way I was going to expect a serious conversation with this man. He so far has been incapable of doing so with any of the other so-called guests that he's had on his channel. So I entertained the idea, but I figured I would get a second, third, fourth, fifth, sixth, 500th opinion, and post the question on Twitter. And what really moved my decision was Betero and the way that he worded it. I mean, the guy right now who just filed and sent to the Commonwealth a blueprint for how he plans on holding everyone accountable for the corruption that's taken place, at least in the court, in in at least 2 cases. I'm gonna listen to that guy when he says probably not a good idea, and I'm gonna listen to like basically I'm gonna take that advice as coming from my unofficial social media attorney. That's free advice from an unofficial social media attorney right there. You would do best to heed such advice. Any person with any common sense. So, and part of me is like, part of me was like, well, I got this muted. Sorry. Part of me was like, well, kind of like Marty in Back to the Future 2 and 3. Nobody calls me chicken. And I was kind of letting that influence my decision a little bit. Because what I was gonna do was basically there's no debate. I was just gonna let him up here, and then I was just gonna fucking cut him off with sound bites the same way I fucking do when I review his shit. And I used to have this rule where if I reviewed you, you would have an open invitation on this channel. The problem with that though is when it comes to this particular case, it's not the same thing. It doesn't apply. Okay. That's for people who I find to be dangerous. I don't find Plevin to be dangerous. Plevin is not a threat. Nobody's listening to Plevin. Nobody with any substance is listening to Plevin. And pretty much virtually when it comes to numbers in regards to YouTube, nobody is listening to Plevin. So why in the fuck would I, bring him up here and put him in a position to where, you know, he could just regurgitate the same old bullshit, and then I'm supposed to act like I'm taking it seriously when I can't act like I'm taking it seriously because it's not serious talk. It's asinine. It's stupidity. It's out of his ass bullshit. So what do you mean? What's wrong with my audio, Sherry? Hold on. Yeah, I don't think. Man, I don't know. My audio bad, guys? My audio is bad. Okay, hold on a second. You're saying that I sound like I'm underwater. Okay, hold on a second. Hold on. Is that any better? How's that? Does it sound muffled now? So that's better. Better, but still weird. I mean, I've got my mic plugged in. It seems to be fine. What about now? I am playing audio. What if I mute this right now? How's that? Is that better? So, okay, it's perfect now. That's because I don't have now I have the Court TV muted and there's a bunch of white noise. So I guess the white noise from Court TV was affecting. Okay, we got to figure it out. Cool. Yeah, the white noise from Court TV, as long as I have it muted and the white noise doesn't come through. Now, hold on. Something's happening here. No, nothing's happening. Okay. All right. Yeah. So, in regards to Plevin, the only thing that would happen is that he's going to come up here and I'm going to I'm not going to take him seriously and I'm going to make fun of him and I'm going to play music over him talking and I'm going to, so, you know what I mean? It would have been pointless. And, it wouldn't have been pointless because what would have happened is super chats would have been fucking pouring in. Everybody would have logged on to see it. Super chats would have been fucking pouring in. And so on top of that, I would have it would have just been stupidity, like just pure stupidity. Like it would have served no purpose but for me to make fun of him live instead of like in an actual conversation rather than and that would have been it. And so A, he should be thanking me for declining this, and B, if I'm such a grifter, why didn't I do it? Because the only person that would have benefited from it would have been me. Between our two channels, the only person that would have really benefited from it would have been me. It would have been the same people that we all know who already make a conscious effort to not subscribe or click on your videos. They click on your videos here. They watch you through me. So, yeah, you're welcome. Now we're just waiting on this hearing to start. Yeah, Scott McGinnis. I mean, that's all it was. It was just, yeah. But I did consider it, and honestly, it's better for him that I don't. So, like, it's so funny because, like, when you think about Sarah Boone and why is this taking so long, like, the only thing I could think of is just like she's probably giving somebody a hard time. She's probably like making life totally difficult for somebody, probably arguing with her lawyer or yeah. Well, hopefully it starts soon.
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. Dad, 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 dad. I think we got a super dad. I think we got a super dad.
I'm playing the whole thing. We're going through the whole thing for Cherry's birthday.
Super dad. Super dad.
Hell yeah. Happy birthday, Cherry. Happy birthday, Cherry. Oh my goodness. Cherry is always in her birthday suit. Look. And even Aaron is wishing you a happy birthday, Cherry. Even Aaron. What's up, Top CPU? Scott McGinnis. Yo, has everybody hit the like? I'm trying to grift here, bro. Hit the like. Yeah, Rod, she found a lawyer, dude. That I can't believe that ad that she made worked. Like, I wish I knew when this was going to start. Is there a hot mic moment? Let me see. No hot mic? No? Dang. I want to hear what this guy had to say. All right. Now, guys, like I said, after this hearing, we're going to go over the Brian Walshe hearing that took place earlier. We will be covering the Brian Walshe case because guess what? I'll give you guys one guess who the judge is in the Brian Walshe case. One guess. One guess. Yeah, Aaron. Yeah, Aaron. Yes, wait, Ted. Wendy Mueller. Thank you for becoming a member. Appreciate you. Dude. Yeah. Same county, exactly. Dude, now here's the thing about let me get into that a little bit. I'll repeat this when we start talking about it. But here's the fun, interesting thing about the Brian Walshe case. Well, there's two very fun, interesting things about the Brian Walshe case. Not so fun when he fucking walks, but if we're trying to find the comedic tragedy in all this shit, you have the fact that Michael Proctor was the lead investigator on that case, and now Michael Proctor's credibility is absolutely and totally fucked. Now, that's a good thing because Karen Reed is that much closer to being exonerated. But the problem is that what we should be looking at is that Karen Reed wouldn't be charged in the first place if there wasn't a corrupt piece of shit like Michael Proctor running the investigation. Now, on top of that, the most damning evidence against Brian Walshe is his Google searches, which were recovered using what software? Yes, I think you've got it. Yes. Celebrate software. And so I'm going to think I think it's going to be very interesting to see what the Commonwealth is going to do when trying to when the defense argues the credibility of Celebrate, because the Commonwealth argued the credibility of Celebrate during the Karen Reed trial. So I'm really interested in seeing how that's going to turn out. So this Brian Walshe case is extremely relevant to the Karen Reed case. Oh my goodness. Thank you so much, Tara, for that PayPal. That is incredibly generous. I really appreciate it. Oh, Aaron, without question, I think he's absolutely guilty. I think he's absolutely guilty. 100% guilty, I believe. I think we're talking about a really, really, we're going to get into what I'll do after this hearing. What I'll do, that'll be something that I'll discuss. Because what I've got in the works right now, folks, I've got a 12-hour live stream in the works right now. And I'm going to be streaming for 12 hours straight, and it's going to be, the purpose of it will be to raise money for both Karen Reed's defense and Turtle Boy's defense. So I'm going to do this, and I'm not sure when just yet, but it's going to be very, very soon, like soon. So what I'll do is I'll do an entire Brian Walshe breakdown during those 12 hours. Because the Brian Walshe case is extremely relevant to Karen Reed's, considering some of the same players. So I'll brainstorm what I'm going to be doing for those 12 hours as I'm live talking to you guys. Because I always do shit just by the seat of my pants, man. Did I just say do shit by the seat of my pants? I just said do shit by the seat of my pants out loud. I totally just fucking did that. Oh my God. Jesus. No. Terrible. No hot mics? Nothing? No hot mics. What's up, Microdots? If you guys don't know, you better know. You need to sub to Microdots. Microdots is amazing. Yeah, that's another thing I'll do too. I'll do like a little Microdots tribute. We'll spend a little time watching Microdots videos. I just have to schedule guests. That's what I have to do. I mean, I could fill 12 hours up here. I just have to I have to get some guests. And I am hearing rumors. Of something in the works that I'm not even going to begin to display details, but I am hearing rumors of something in the works that sounds quite intriguing, that I may end up taking part in. But yeah. Well, Cherry, you haven't been here. You know, I've been talking about for like the last 2 or 3 live streams. I've been talking about this 12-hour stream that I've got kicking around in my head. But yes, we will discuss it behind the scenes in detail. Clever, dude. Can I stretch my legs? Is that okay? Can you come lay down over here? Please? Buddy? Good boy. Good boy. Thank you. Thank you. The 12-hour stream will be a fundraiser for both Karen Reed and Turtle Boy's defense. Here's the thing about Turtle Boy's defense, folks, is he got framed. Like, there's no fucking denying this shit at this point. Like, the dude got railroaded, man. Like, there's no, it's not even, oh, I don't know, did he? No, it fucking happened. Dude, Krusty, fake victim, Tully, Mello, they all fucking colluded to railroad this guy. It's a fact. And Betterow and Bradle can prove it. The Killer Bees can prove it. This is happening. And so yeah, dude, it's not 99.9%, bro. It's 100 fucking percent. Absolutely. I've never been so sure about raising money for a fucking defense, dude. For two defenses. I've never been more sure and feel morally sound in doing so. Never in my life. Like, I'm doing this fundraiser with my whole fucking chest, dude. There's no question about it. Like, these people, I want to see them fucking body slam the Commonwealth. Like, I am trying to see that shit. Like, figuratively speaking, I want to see Turtle Boy's defense body slam the Commonwealth. Bowl the fuck down some corrupt assholes. I can't wait for that shit. Shit's gonna be insane, dude. For real. Like, I'm not even trying to lie. I want Betterow eating Capitol Grill all he fucking wants throughout this thing. I'm not even trying to lie. Like, that dude, I want him in an absolute state of fucking comfort. And yeah, the entire time he is taking down this fucking this umbrella of corruption, at least in this case, at the very least in this case. I can't wait for it. Like, and it's inevitable. That's what's so funny about it. It's inevitable. All right, still no sound, guys. Just checking. Yeah, Aaron is here, dude. Listen, me and Aaron are cool, man. I feel like Aaron's coming around. He seems a lot more respectful. You know what I mean? Listen, people, kindness works, dude. You know, when you got people who, because if you really think about it, man, Aaron, all he's done in the chat is ask questions. That's why he wasn't booted at any point. He's just asking questions. Ain't nothing wrong with asking questions. And he seems to be pretty well educated in what's going on here, and he seems to be pretty accepting of it. I think that's nice. You know, see how it works. I mean, I come off like an asshole, partly because I am, but mostly the thing here is that kindness does work. It you know, just because I'm abrasive, you know. Most of it's just you know, just to be funny and make you guys laugh. That's all it is. I'm not trying to hurt nobody's feelings, bro. You know what I mean? Aaron has been a great sport, and he's welcome here as much as he would like to be. And I'm grateful for his contribution into the chat. No doubt about it. Dude, when is this, like, what is going on here? And what is with her lawyer, bro? He looks like Alfred from the 1966 Batman series. Oh, here's the judge. Here we go. I unmuted it at just the right time. Or you guys hear that fly that's in here, dude? There's a fly in here right now. Clever was trying to get it. I don't even see Clever right now, so I think he's trying to get it in the other part of it. Did you get it, buddy? Did you get it?
Cork, I'm ready when you are.
You catch straw on behalf of the state. William J. for the state.
James Owens for Sarah Boone.
I do.
Good afternoon, everyone. Ms. Boone, good afternoon. If you could please state your full name and date of birth for the record for me.
Sarah Boone, 10-10-7-7.
Okay, we're here on several different matters.
Who did the sound in this? Plevin? Jesus Christ. Who, dude, why are they using Plevin mics and eating them? What is going on? I have to find another. Hold on. This is not going to work. Law and crime. See, this is why I don't fucking stream you guys, bro. This is why I don't snipe you motherfuckers, bro. See? You see? Let's try. Oh my God. It's the same thing everywhere, bro. This is awful. Yeah, but it's just as bad. This is Court TV.
Good afternoon, everyone. Ms. Boone, good afternoon. If you could please state your full name and date of birth for the record for me.
Sarah Boone, 10-10-7-7.
Okay, we're here on several different matters, including a motion to suppress.
I'm going to turn this down, bro.
The motion to suppress defendant
That's just a lot.
At OCSO filed September 24.
You guys might have to put in headphones.
The amended motion to suppress defendant statements at OCSO filed September 30, 2024. And then just what was filed this afternoon at 2:35 p.m. Defendant's second amended motion to suppress defendant statements at OCSO. State, have you had the opportunity to review the second amended motion? Are you ready to proceed on that today? Okay. Are there any housekeeping matters we need to address from the state side of the ledger?
Not on that motion.
Okay. Any housekeeping matters on your side of the ledger, sir, with regard to those motions to suppress?
No, sir, Judge. I believe we've got two detectives outside to testify, and we've also got the custodian of records from the Orange County Sheriff's Department relating to the Miranda card and the policy.
Is that a valid argument that you're still embarking on this afternoon based on what's in your second amended motion?
Yes.
Okay, so the sufficiency of the Miranda waiver is still at play?
Yeah.
Okay, all right, thank you, sir. With regard to the other motion.
That's as loud as I'm going, y'all.
And I have reviewed the state's motion to strike, and I have reviewed all of the case law authorities that y'all have provided to me as well. With regard to the defendant's motion for hair, cosmetics, civilian and clothing without restraints for trial, Mr. J, do you have any position with regard to the restraints at trial portion of that motion?
I believe the law of the case has already been settled on that issue.
Okay, all right, we'll entertain argument when we get there. And I've also reviewed the state's request for protective order filed September 30, which is also set to be heard this afternoon. With that, we'll begin with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting to the authenticity of whatever it is he subpoenaed.
I've been given some of the documents. Orange County Sheriff's Office General Order 711. I don't see any need to belabor the custodian of records sitting around. Was there something else? You're actually a Miranda card? Or
Yeah, if you look in the very back. If you look in the very back.
Okay.
You see the Miranda card. The last page is next to the last page.
Yeah, there's no need to keep the custodian of records around for authenticity. We still have our objections.
Okay, all right. Can the custodian then be released by virtue of the state's stipulation as to that, those records?
Yes, can I go tell you?
Yes. I also have
yeah,
reviewed
Boston,
the
Mass.
2 hour and 6 minute investigation that's pertinent to the motion to suppress. The court has reviewed the entire video. With that, state, you may proceed.
State would ask the court for the clerk to mark A for identification is a DVD.
So they're calling a witness, but the trial hasn't started yet, has it? I thought this was just a motions hearing. But I mean, I guess you can call witnesses in a motion hearing. I just didn't know that.
In advance of today's hearing. Any objections?
No objection.
What was pre-marked as states A will be received into evidence without objection as states 1. Good afternoon, ma'am. Could you state your full name for the record and spell it for us?
Yes, it's Chelsea Castle. Chelsey. Last name is Aoepsel.
Can you eat the mic like the judges?
Where do you work, ma'am?
The Orange County Sheriff's Office.
And what do you do for Sheriff Mina?
I
How long have you been a homicide detective?
over 6 years.
And what's your total experience with the Orange County Sheriff's Office in terms of years?
I am going on 12 years.
Yes,
Any
thank you,
prior
Kate.
law enforcement experience prior to joining the Sheriff's Office? And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So for this case specifically, my team was on call that week for homicides. And so the deputy on the scene would notify the call center to notify the on-call homicide.
All right, and is it fair to say that you guys have 3 teams of 4?
Yes.
And each of the third weeks you will be on call?
Yes.
And then through some other random distribution, it's determined who of the 4 will be the lead?
Correct.
And it was your turn to investigate the death of Jorge Torres?
Yes.
And you were notified of this on February 24th of 2020 in the afternoon?
Yes.
About what time were you notified?
I would have to look at the CAD sheet to recall directly, but I would assume within 30 minutes to an hour of deputies being on scene.
Y'all need to stop.
Right, and do you go to the scene first or do you do anything else?
Quit objectifying the cop, y'all.
For this particular incident, I got my
I mean,
partner,
but she is
Jessica
fine though.
Lowen,
I mean,
and we headed out to the scene.
she is.
All right, and when you got to the scene, what did you do?
Y'all can sit there and drool over crash daddies. We can't.
The deputies there.
We can't drool over the hot
briefing me on
detective.
What was going on and what they responded to.
Did you do a walkthrough of the scene?
I did. Yes.
And then was a search warrant drafted for the residence
Yes.
and later executed?
Correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes,
Do you see Sarah Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's over here on my left, and she's wearing blue.
May the record reflect she's identified the defendant.
Record will so reflect.
When did you first have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there. So once I spoke with deputies, I then went and introduced myself to her.
All right. And did you ask her any questions at this time as you guys are standing outside of the residence?
Not like detailed questions about like what happened, because I already was told by deputies what she had told them. So it's more just to like introduce myself and to let her know, you know, we're doing a search warrant and the procedures of how we do things.
And when you respond to a scene, do you respond in plain clothes?
I do, yeah, like business professional.
Like what you're wearing?
Yes.
And when you made contact with her outside of her residence for this first contact, were you alone or was your partner Scott Lowen with you?
I believe Scott was with me.
And was he also similarly dressed in business casual?
Yes.
All right. And so how long was this initial interaction with Ms. Boone?
Not long. Maybe a couple minutes to a few minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, like sitting out on their like front porch area.
Do you recall what you asked her in this initial contact?
Do I recall what?
You asked her?
No.
Okay. So it was just a couple of minutes that you were there with her?
Yeah.
Okay. And then what do you do after your first contact with her?
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else. And then once that was executed, we went in there further with CSIs. And then we talked to Brian Boone, which was the ex-husband. And then I believe we then sat there and into our unmarked vehicle and had a conversation with her.
Y'all are haters.
Was that conversation in the unmarked vehicle recorded?
Is
Can you
she
describe this
bright?
unmarked vehicle
She's
for the
pretty,
court?
but is she bright? Stop
At
it.
the time, I was in a unmarked
Meow.
Pathfinder, so it was like gray in color. Didn't look like it didn't say like law enforcement or police or anything on the exterior. And there were lights like inside.
Where did everybody sit in this Pathfinder?
I sat in the driver's seat. Sarah sat in the front passenger seat, and Dr. Scott Lowen sat in the back seat.
Did you have any conversation with her about the facts of the case or your investigation that wasn't recorded inside the car?
No.
And that was all recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the start of this interview on that recording, did you not?
Correct.
Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for 911?
Yeah, I would say, yeah, because I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Ms. Boone?
Just based off the situation and what was happening.
Okay. Is it in any way unusual to gather evidence before talking to the last person to see a decedent alive?
No.
At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was
And when was that?
that same day.
I mean, when time-wise and in relation to talking to her?
Oh, well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSIs documented everything, photographs. So I don't think I really touched it until after I had talked to her about going through it.
All right. And ultimately, was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Yeah. Not go back in her house. But
Prior to that, had she been detained and requested not to leave the scene?
One more time.
Prior to your interview with her in the car, had she been asked or ordered to stay on the scene?
Not by me.
February 25th, was there a second interview conducted with you and Detective Lowen with Ms. Boone?
Yes.
Prior to this interview, had her phone been extracted by any member of the digital forensics team at the sheriff's office?
Yes.
All right, and had you reviewed some of the evidence on there?
Yes.
You had requested that Ms. Boone come down to the sheriff's office rather than you returning to the scene?
Yes.
Can you explain that?
It's more of a controlled setting for law enforcement. We were able to audio and video record at the sheriff's office, and she had mentioned that she might not be staying at her apartment, and so I didn't want to go to the ex-husband's residence where her potential child was, so I just felt it was a more controlled setting at the sheriff's office.
All right. And when Ms. Boone arrives at the sheriff's office, who goes down to greet her and where?
It was not me. But she would have gone in through, we have two entryways. So either on the record side or on the opposite side. And she would have had to go up to the window and request that she was there to meet with me. They would call me. I would tell them yes, sign her in. And then if I'm not mistaken, I believe Scott, Detective Lowen, went down and got her.
All right, so you're describing two separate entrances that members of the public can come and go through?
Yes.
As opposed to separate entrances that might be in the back of your building where people are not free to come in and out of without a swipe card?
Yeah, the public doesn't have access.
All right. Now, in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Where are the CID or the investigation division's interview rooms?
They are located upstairs.
All right.
Second.
And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with an employee of the sheriff's office.
And your testimony is it wasn't you?
And I don't believe so, no.
Now tell us about these interview rooms.
We have 4 interview rooms that are audio and video recorded.
Okay. And they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the sheriff's office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't have other questions of this witness.
Thank you. Any cross-examination? Yes.
Detective, I'm James Owens. I met you outside just a few minutes ago, and you know I represent Sarah Boone. Detective, have you had a chance to review any paperwork related to this case prior to this hearing?
I have looked at my investigative report, and I have looked at some policies, but they were from current.
Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Would it be fair to say that prior to you asking Sarah Boone to enter this unmarked vehicle for this interrogation with Detective Lowen, that you did a preliminary investigation as to whether or not this was potentially a homicide?
Yes.
And you would have viewed the scene inside the apartment?
Yes.
Why would I not
And you
think
would have
it's
spoken
potentially a
to
homicide? He was in a
Deputy
suitcase.
Rodriguez about what she knew about the situation?
Yes.
and you would speak to Deputy Rodriguez about what Sarah Boone had said had happened?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Potentially. I didn't listen to that interview. I don't
Okay.
know if we interviewed him outside or in my car.
Was he Mirandized?
No.
Okay. So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or person of interest?
At some point, yes.
Tell us when that happened.
The next day.
Okay, so at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult to the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation.
Right.
But due to
Process of elimination,
not
dude.
having, the autopsy results, we just interviewed her initially, got her initial statement, and then pending, once the autopsy was completed the next morning, was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized and she went to jail later that evening.
While you were there on scene, I know at some point you saw her phone on the kitchen counter?
I did.
All right.
Or maybe on the microwave. It was somewhere in the kitchen.
All right. And at some point you went to Sarah Boone and you asked her for the password to open the phone.
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay, so not before? You didn't ask her before you asked her to sign the consent form? Sarah, give me the password to your phone.
Not that I recall, but I would normally have her sign the consent form first for her consenting to go into the phone and then gather the passcode or whatever it is.
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to searching the phone?
You ask.
Called 911, so I told her that
What?
we needed to corroborate her story as to what occurred.
Okay.
And so to do that, I wanted to go through her phone.
All right, do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Was it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, did your testimony is you asked her for her password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital came.
All right. You're talking about the digital investigator? And they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh yeah, she didn't come until later. I believe around 7 p.m.
Okay.
That's when in the CAD sheet it says she arrived.
And you know, there were two videos on Sarah's phone.
After I spoke to Sarah.
I'm sorry?
After I spoke to Sarah?
All right. So what I'm gathering from what you just said is at some point you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
Where we completed an interview? Yes, sir.
And your testimony is that you did not view the videos that were found on her phone, and I'm referring to the 2-minute video of George in the suitcase, and then some time went by, and I think there was about a 22-second.
Yeah, just so you guys know, like I don't
video of
have
George.
I don't have control over. I mean, I can only
Testimony
keep
is
this.
prior-
I can only keep this so loud. It's the sound that is in the courtroom. Both court TV and Law and Crime they sound the same.
Forensics came out and then went into her phone, and then she brought me over to her van to tell me about the videos and what she found.
All right, so your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived?
Correct.
Okay. Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah before y'all got in the vehicle?
Of course.
And did you tell Sarah that y'all wanted to talk to her and this was routine protocol?
Yeah, that I wanted to have a conversation with her, and once I had walked through the house and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically said that, sir. This was 2020.
Okay. If she recalled that, would you dispute it?
Objection, improper question.
Sustained.
Your testimony is you don't remember saying that.
I don't remember specifically saying what. One more time. What is it that she claimed that I said?
Routine protocol.
I would not interview her, not in my unmarked car. So my routine protocol, sure, I would do that. I would interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car?
Yeah. Yes. Well, you would have to tell her something.
Yes, we're going to go have a conversation in my car.
What's he trying to do here?
And did she have any questions that you recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat. We were going to talk about the vehicle, yes.
Okay. And you don't recall whether or not you said this is
I
routine
love it.
protocol to come into the car and talk to me?
Those words specifically, no. But I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
All right. Now, once inside the squad car, you were there with the other detective,
This is
Detective
a
Lowen.
lovely defense attorney.
And
That's what
you read her the Miranda rights.
It's not quite as boring.
Correct?
Yes, from my car, yes.
Do you agree that you didn't ask her the last question, number 9?
Objection, relevance.
Response.
Judge, we're here on a hearing on the issue about the interrogation.
But of the case law that you provided to
Yeah,
me,
his questions
none of
are
it stands for the
ridiculous.
proposition. Miranda identifies.
That's what a
the four
defense attorney
things that
does,
need
not
to
a
be
prosecutor.
addressed.
That's why it's so suspect.
Not one of the cases talks about that issue of reading that language at the bottom of the card.
Lally played
is a
defense
motion
the whole
on
time.
Information and belief, this is what it says. So how's it relevant for the purposes of today?
Well, it's relevant because this is the policy of her department.
But
Judge,
what does the policy have? But now we're getting away from the card to now the policy. There's nothing about the policy right now. The question is about what the card says.
Okay. The card is the policy, and the policy is the policy. They're intertwined. They refer to each other. Our
What?
argument is that she did not waive her rights.
But
Remain silent.
that's a different issue than what is on the card.
I understand, but it's a coercive question about her not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the sheriff's department. She elected not to answer a question that the policy says read verbatim from the card. Why did she not want it? Our position is it was an attempt by this detective to coerce Sarah Boone into talking.
On February 24th or on February 25th?
On February 25th, this interrogation ties into that one. She used the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm sure I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. If she understood her rights, and then she consciously and freely waived her rights. She was not asked that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider, as to whether or not that statement should be suppressed.
Any other?
Oh, you're actually making a great point.
What the sheriff's office policy.
Okay, I see what you're saying, Kelly
what
R.
The Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida, or the United States, and federal case law and the state case law interpreting the United States Constitution. The policy is irrelevant, and the officer's subjective intent is completely irrelevant in a motion to suppress, just like it would be in a traffic stop under Wren versus United States. What matters is objectively what was spoken to the defendant. And I would ask that we honor the local administrative order and call people by their surnames and not their first names.
How dare you, sir?
Is that
he saw him all turn around all quick.
Was read what the
This is
case
going to be
law
a spicy
requires.
trial, y'all.
Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both the parties.
Last bite at the apple.
I'm sorry.
Last bite at the apple. Last bite at the apple. Any other argument?
We're talking about the coerced or not. You can take any technique or a non-technique, something that you use or don't use, to establish whether or not it was coerced or not. The fact that she didn't read, do you understand the rights? Do you understand these rights, which is the form, the Miranda warning form? Do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you. And you're referring about surname. What do you mean by that? You mean
he's not letting it go.
Last name.
okay? What did I say? This detective?
Keep calling the defendant by her first name.
All right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone. That's fine.
Okay.
You may proceed.
I mean, that is a little inappropriate.
Have you had a chance to look at the standardized Miranda card
My
issued
defendant
by the Orange County
homie,
Sheriff's Office?
it's like that doesn't work, bro.
Do you agree?
My client homie,
that you did not read the 9 questions to her in your squad car?
All 9 questions?
Correct.
No, I did not read all 9 questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my Miranda card.
I'm sorry?
It's not on my Miranda card that I read from. Continue.
What do you mean by that? It was the card that you read, it was not on the card?
yeah. So, do you understand these rights is not on the Miranda card?
Yes, that is the in reference to the policy. Yes, that is the policy.
Well, somebody dropped the ball somewhere. Did you fail to get
Sustained.
did you
Yeah,
fail to
dude.
get the most updated card, or how did that happen? That the 9th question was not on your Miranda rights card?
I've had that card since I started being interested in sex crimes in 2013.
Have you become aware, as it relates to following this motion,
I've become more aware, yes, that there is that card.
have you gone and gotten the updated card?
Objection, relevance.
Sustained.
Yeah, that's the argument, Grant's pants. That's the argument. Like, it's a hell of a technicality to catch, you know, for a dude who's having a real hard
When y'all
time
took her phone,
being
detective,
professional.
did you tell
He's
Sarah
got a good
Boone
angle here.
that you would be returning to her apartment the following afternoon to give her her phone back? You did not tell her that. Or tell me what you understood the conversation was as it relates to her getting her phone back.
I'm sure she asked when she'd be getting her phone back, and I didn't give her a detailed timeline. I said that, I don't even know if I told her that I decided to write a search warrant on it because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, and so I took it, and I wrote a search warrant for it.
Okay. But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
Specifically returning her phone, no.
Okay.
The
Do you
thing
recall
is,
her calling you later that evening on your cell phone?
this feels like a moot point because there's video evidence against her. Like, you know what I mean?
From her
There's so
husband's
much
phone?
else.
You don't
Everything
recall that
she
conversation?
did
She called you
after
later
being
that
read her
evening?
Miranda rights.
Do you have documentation of the phone call?
I have her testimony.
Oh, okay. Well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
I mean,
You said that y'all had some
he's doing his job.
discussions
I would
about
play that
Sarah Boone
angle
coming to
too
the
if that's
station. Was
all I
that
had.
talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And did you relate to Sarah Boone that she needed to come to the sheriff's department the next day to retrieve her phone?
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you?
Something along those lines.
Okay. And when was it that you actually saw the two videos from Sarah's phone? Was it that evening after the interrogation in the
For
squad
sure.
car? All right, and was it while you were on scene? Okay. And did you attempt to talk to Sarah again about that at that time? Okay. And so did you let your detective partner know about the videos on Sarah's phone?
Objection, relevance.
Overruled.
Did you let your partner know about that evidence? Okay. And did y'all discuss that issue?
Objection, relevance, work product.
Sustained.
At some point, y'all had to, were y'all working together, or were you making all the calls, or were y'all making joint decisions?
Objection, relevance, work product.
Sustained.
Ma'am?
There's no pending question at this time, ma'am.
At some point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection, relevance.
Overruled.
Yes, at some point I did.
Did you make that decision by yourself, or was it collectively made by others with the department?
Objection, relevance.
Sustained. You don't need to answer anything.
Detective, at what point did y'all, that next day, I think you had her coming in the afternoon?
I believe it was on 3 p.m.
Did y'all work on trying to get the search warrant for the phone?
Did y'all work on?
I got the search warrant for the phone, and I believe I submitted it that evening. I would have to look at it though.
Okay. Do you know what time the search warrant came back signed by the judge?
She's got kind of like a Latina Scarlett
And would it be fair to
Johansson
say
thing going
that
on.
You told Sarah to come in later that afternoon or the next day?
Yes.
Okay. And would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
Yes, I attended an autopsy in the morning. That's why I asked her to come in.
All right. And what time was the autopsy that morning?
It starts at 8, but I did probably get till 10. It takes quite a few hours.
Okay. And were you there alone with the medical examiner, or were there anybody else there?
I don't recall if Detective Loan was with me or not, but yes, of course, there's doctors there.
Okay. And so in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video, the two videos from her phone the day before the autopsy?
Objection, relevance. Custody is not disputed on the February 25th statement.
How's this relevant? If the issue is knowing an intelligent waiver, the sufficiency of Miranda
Judge is
and
not having
coercion,
it.
What does the formulation of probable cause have anything to do with anything?
Well, I wanted to bring out the fact that
Everyone is now
they had
dumber
already made a
having
decision
heard what
before
you
she
just
came
said.
in for the interrogation on the 25th that they had probable cause to arrest her. So that if she, A, either didn't come in, they were going to go arrest her that day, or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway, that they had already made a decision that she was the prime suspect. They had probable
What does that
cause.
have to do with any of the three issues that are raised in the motions?
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
I think my
Baby
response.
That's my understanding. The state's not disputing that there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided prior to that.
Judge, it was provided the day before, and she's just testified.
Bro. What are we doing?
She was free to leave at any time.
Okay.
So the Miranda was given on two separate occasions. She wasn't in custodial interrogation. Detective, am I right? The day.
Well, hang on. Before we ask any questions, let's deal with the evidentiary objection first. The objection is sustained.
Okay.
You may proceed.
All right.
Let's chill.
Ma'am, you would agree that
Let's
when
just
Sarah
don't
Boone
try to
arrived
chill
that
with
afternoon
the
for the
evidentiary.
interrogation, she was not free to leave.
She was not.
Excuse me?
She was not going to be free to leave. No.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway.
This is going to be a hell of a trial.
And that was based on your investigation that you had the night before at the scene. It was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the two videotapes that you saw from Sarah's phone.
Objection relevance as to what the probable cause basis.
Sustained.
You had all that information before you began your interrogation on the 25th of Sarah Boone.
I had all what information?
All the information that I just related to you before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you
What do you mean
wanted
you can't
to
hear the
speak to
judge?
her.
The judge is the
25th.
loudest one.
Relevance.
Overruled.
Yes.
Okay. And would it be fair to say that you wanted to get statements from her relating to the injuries to George Torres from the autopsy?
Objection relevance.
Overruled.
Yes, I wanted to have a follow-up conversation.
I mean, the judge is letting him, he's giving him some leeway here.
And you also wanted to question her about the two videotapes that you had found on the phone.
Objection relevance.
Overruled.
Yes, I do
Okay.
want to show her the videos.
And you agree, in your opinion, the two videos and the autopsy were inconsistent with the story she had given you in the squad car the day before.
Objection relevance.
Overruled.
I mean,
The videos.
I see where he's
Sorry,
going with this.
Repeat your question one more time.
You would agree that the autopsy results and the videos that were extracted or taken from her phone, recording George, those two pieces of evidence from your investigation were inconsistent with the statement that she had given the day before in your squad car.
Same objection for the record.
Overruled.
Yes.
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection relevance.
Sustained.
Yeah, this
Now, you
judge
said
is
you had a
engaged, man.
chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
The Orange County Sheriff's Office.
The Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video with the audio.
Okay, have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I've not looked at your motion.
Okay. Do you recall you saying to her, I'm going to have you sit in the green chair?
Objection. Best evidence is the recording.
He's right.
Okay.
Objection sustained.
Okay. Do you agree, prior to reading Miranda, that you mentioned to her that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that, referring to the autopsy?
Objection. Best evidence.
Sustained.
Do you recall making some comments to her prior to reading her the rights?
Objection. Best evidence.
Overruled.
Yes.
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Objection. Relevance.
Overruled.
One more time.
I assume that's not the first time you've read Miranda to a suspect.
Objection. Proper question.
Sustained.
Let me go back to the first question then.
I mean, dude, this
Is it
dude.
the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Ooh.
Overruled as relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Objection. Proper.
Sustained.
How long have you been with the Sheriff's Department?
Since 2013,
How long have you been a homicide detective?
over 6 years.
Okay. Have you ever been trained or told to ask or not to ask any statements or any questions prior to reading Miranda relating to them talking to you?
Objection. Relevance.
Sustained.
Well, how are you supposed to get them to talk to you then?
Can you tell us if you recall saying anything to her prior to
Oh,
reading
this
her
guy's
Miranda?
reaching now because
I recall briefly talking about getting the autopsy results, and I wish to have a conversation with her.
All right. Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection. Relevance.
Overruled.
I did not ask her question number 10.
Okay. Do they have a Miranda cards form in the interrogation room? So you would have had that on your person?
good, buddy. Thank you, Kelly R. I mean, I'm still shaky on how it went down, but the dude seems to be making a good argument. It just depends on what she said in the vehicle, in the unmarked car. It just depends on what she was asking her in the unmarked car. That's the big question here. Because how else are you supposed to get them to? I mean, hey, would you mind coming down to the station for an interview? And then once they sit down, they hit record, they go, hey, so just, I'm going to read you standard your Miranda rights, just so you know. And, you know, we're recording, and that's normally how that goes down. So how are you supposed to get her to come down there and do that unless you ask her and let her know, hey, there's things I'd like to talk to you about. So, and I think that he's just trying to exploit that. So I don't know. It just all depends what she asked in the car.
Waivers and affidavits.
Is that a filled out of waivers and affidavits?
It's filled out by me, but
I agree. It has to be done right. Of course. That's what I'm asking, though. What happened? You know what I mean? Was it done right? Is the question.
we're talking about just this top, right? Okay, I'm sorry. Does it what?
Does that form, is it filled out as it relates to Sarah Boone?
In the case, yes.
Is that her signature or what?
Yes.
Did you see her sign it?
Yes.
Is that your signature below?
Yes.
And is that the consent for the phone?
The consent to search, yes.
On that form, is there also the Miranda warnings?
Yes.
And that is a form that's standardized by the Sheriff's Department?
Yes.
And you did not read a Miranda from those rights?
From this piece of paper?
Yes.
That's audio and video recorded? No.
Okay. You agree that there's 9 questions on that form?
Yes.
Judge, I would like to offer this.
Same objection to the relevance. As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave a statement to the detectives. And again, under the case law, there's no requirement for this question 9.
Leona, thank you so much for the Venmo.
Any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the 5th Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness of her waiver of her Miranda rights.
Response.
Judge, obviously we disagree.
Then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean, State versus Owens.
Shit I ever heard in my life, Scott.
State v. Thomas,
Jesus Christ,
Powell from the United States Supreme Court, which reversed the Florida Supreme Court decision. I'll talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that, Judge.
The right to remain silent, the right to an attorney before and after questioning. If you can't afford one will be provided to you. Everything you say can and will be used against you. Those are the things that Miranda highlights. That Miranda opinion itself says that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell, and then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state, identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
Okay, I want to finish my argument.
Okay.
She has a duty.
I love that
to
the
read the
judge
rights.
is arguing this.
She has an obligation to
The
ensure
judge.
that Sarah Boone understands her rights by asking that question. Do you understand the rights I've just read? And then there
That's
must
what
be
he's
a
trying to
waiver.
get her on.
Yes, I understand the rights, and I agree to speak to you now. So for that to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with the detective is she reads the rights, do you understand the rights? And then she goes right into questioning. She goes right into questioning without saying, do you agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given the statement, and whether that waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the Sheriff's Department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question.
She's not going to walk
testify
over this,
about
dude.
what she perceived at the time that the detective failed to read that question and how it ties into the case. I understand that all they have to read is those 4, but I think under the totality of the circumstances standard that this court has to apply, that
No,
that should
yeah,
be a
I totally
consideration the
agree.
court should consider. I know
I
it was
would
an honest
play this
mistake.
myself. I would.
She had an old
If
car.
I was a lawyer, I'd
But
do the
still,
same thing.
I feel like it should be considered in your decision.
Anything else, Mr. J?
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection as relevance by virtue of the decisions in Thomas 351, Southern Third 197, and Owens 41, Southern Third 352. There's, it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
Do you
Yeah.
agree, Detective, that after you read her
Yeah. So read different,
those
ask different questions.
Miranda
What are you
rights,
saying? Okay, that wasn't me. I didn't do that. That shit just froze. I don't know why. Oh, see what I mean? I didn't do that. All right, hold on a second. Let me see what I can do here. See what kind of magic I can work. Oh, wait. Something else is happening. Hold on. Let's see. Boone's culpability is pretty questionable, but these cops got to do it right. Facts. No. Okay, while we're waiting for that shit to come back, let's discuss this for a second, because I see there's a lot of split opinions. And I'm right down the middle with you guys, man. I'm telling you. Because here's the thing, this lawyer, he's doing his job. He's doing exactly what he's supposed to be doing. Okay? He's finding loopholes. He's poking holes in the case. It's his job to find technicalities. It's
you would
his
agree that
job,
the situation
but it's a
on the
stretch.
25th, when you were
That's
reading
all
her
I'm saying.
Miranda and about to question her, was different from the situation the day before when you read her Miranda in the squad car?
Yes, I had more evidence.
That was without the autopsy. That was without the 2 videos from her phone in the squad car.
Yeah, I did at the time of the interview. Yes.
I got it
In the
up all
squad
the way
car, She
now.
was free to leave.
I mean, I didn't tell her she was free to leave, but I mean, if she didn't want to talk to me, she didn't have to talk to me.
Okay.
Wow. Okay. All right. All right. Thank you, Boston. No, that was actually pretty good.
That's all the questions I have at this time.
Thank you. Any redirect?
No, thank you.
All right. Can this witness be released?
I'd like her to stay.
All right. Subject to recall. Thank you.
Subject to read.
State, you may call your next
You
witness.
saw her like
Additional witnesses or
get
evidence
up
in
and
this issue, Judge.
Okay. All right.
okay. All right.
Anything from your side of the ledger, sir?
Sorry, get up and just be like, fuck.
Judge, I would like, you stipulated to the introduction.
No, I don't object to the authenticity.
All right, Judge, I would like to introduce.
I mean, I'm slightly impressed with him. I'm telling you, I have to admit it. I'm slightly impressed with this lawyer for being literally the bottom of the barrel, bro. Like, this dude is the 9th fucking lawyer for this lady, and like, this is pre-trial.
Just that one.
9th.
What is it that's been marked as Defense Exhibit B?
I can't get rid of that taskbar at the bottom of the YouTube. It's driving me crazy. I'm gonna have to refresh. Let me see. See what happens here. There we go. We're good. But there, wait, nope, I'm muted.
Thank you. Any additional argument with regard to the state's relevance objection?
Same argument.
No, I'm sorry, Mr. J, I wasn't specific enough. Mr. Owens, to you, any additional argument?
Same argument.
All right, I'm going to sustain the relevancy objection for the same reasons the court articulated previously. And Mr. Owens, you had one additional exhibit as well?
This is a composite exhibit, which is the policy of the sheriff's department.
Do you know what page specifically those policies are on?
Page 14 of 22.
I follow the evidence.
And I'm going to give you 2 more pages.
Is it beginning of paragraph 4, waiver of constitutional rights?
Yes.
No, I feel like this prosecutor like is already confident this is going to be a slam dunk. Like that's the vibe I'm getting.
Okay, I've read pages 14 and 15.
All right, Judge, and then you go to 13 of 28.
13?
13, it's the next.
Oh, there's 2 different sets. It's a composite. My apologies.
It's split up.
Got it.
13 of 28 at the bottom, P. And then it goes on to the next page.
Yeah, I'm with
14,
you. Reality check.
28.
I agree.
Specifically 2A on 14.
I mean, he's just looking for technicalities that he can exploit. You know, that's his job as a defense attorney. I don't blame him. It's just it's a stretch. That's all I'm saying. Yeah, this Miranda thing.
Anything else?
No other argument, Judge, other than what we talked about.
Anything further?
Same arguments.
Okay, all right. I'm going to overrule the objection as to relevance as to what was pre-marked as composite C, and that'll be received into evidence. Over objection is states 1. I'm sorry, defense is 1.
Petty paralegal nailed it. Judge Ted Cruz. Oh. Did you say Sarah looking good?
Any further witnesses, evidence, or testimony, sir?
Dude.
Judge, I'd like to call Sarah Boone.
Ms. Boone can approach the podium.
You one of those dudes?
She was previously sworn.
Giovanni, are you one of those dudes that like writes letters to fucking these psycho hose beasts?
Yes, sir. Hey, the deputy's got a mover.
What's happening here? Oh, she's taking the stand. Okay. She's going to testify.
Ma'am, you've already been sworn. Counselor, you may proceed.
Ma'am, would you please state your full name?
Here it is. Stop.
You're going to have to speak up or move the mic.
Sarah Boone.
Yes.
Where are you currently housed?
Charlie Lynn.
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase. You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
Could you speak up, please?
What mental state did you have at that time?
I'm talking to the lawyer.
I was very confused.
I can barely hear him.
It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge, move to strike. This is outside the motion to suppress. They have not made any allegations that her statement was involuntary, mental state, or state of intoxication.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation is the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the day before the interrogation.
I understand that.
We're not talking about an
So are
intoxication.
you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes. It wasn't raised in any of the three motions that have been filed.
Judge, I didn't ask her that. She volunteered
I
that.
understand it. Objection sustained and stricken.
Did you speak to the deputy about what had happened?
Yes.
Okay. And then were you asked to stay on scene?
By both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive
Dolly down.
after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to conclude anything.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? Was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hopesall asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Hopesall.
How did you unlock it?
She handed it to me and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
All right. Did you ever see the phone again?
I did not.
Okay. After that incident, was the next time you were spoken to by Detective Hopesall was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything
I
about
needed to go.
what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to the videos that you recorded on your phone from the night before?
No.
Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes.
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes.
And at some point, did they tell you they were finished with the work there at the scene?
Yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Kopsel?
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized?
Correct.
And you had consented to that? You signed a form allowing them to take the phone?
Or you volunteered it?
Have there been any discussion about returning the phone?
Kopsel told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Kopsel's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
Okay.
So it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding the case for me to call her.
Standard.
So I took that to heart and
Standard.
felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this
And
time.
you called her.
You were concerned about the case and you wanted to call her?
Yes.
And did
Yeah,
you,
what do you
did you
know?
talk to her?
Yes.
What did you say to her?
I told her in all honesty that I felt that she was trying to trick me.
Sustained.
She's trying to trick me. She's trying to trick
Did
me.
you have a conversation about your phone?
Yes. I asked her.
Answered.
Oh. You may answer the question, ma'am.
So did you call for a yes or no? She said yes, and now I don't know like what's pending. How
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and
No,
asked
those
me if
two
I
wouldn't
could
work.
help
Levin
when I
couldn't
was being
fit in this
pregnant,
suitcase.
and it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion about you being interrogated at the sheriff's department?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Kopsel was pregnant and not feeling well?
Correct.
So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over at a particular window, and he says, no, your phone is upstairs, so we would just like for you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants
His firearm was on his waist?
the entire time, yes.
Okay. So y'all got off the elevator? Where did you go from there?
He brought me into a very small room and they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No.
Okay. So directly off the elevator and walked into the interrogation room.
Correct.
And then we've got the video on that.
Okay, you
Now-
got the video on that.
You and I have watched the video, correct? And you've seen the motion where I've referred to the questioning where she asked you to sit down.
Yes.
You recall that happening?
Yes.
Did that refresh your memory watching the video?
Yes.
Do you recall her saying that she had received the autopsy?
Yes.
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
Yes.
This was prior to you being read your Miranda rights.
Correct.
And she also said, we're not done talking about the incident. You recall that?
Yes.
And then she said, we just have to do it.
Thank you, reality check.
How did that make you feel?
Sustained.
Were you trying to comply with the officer's demands?
Overruled.
In every way.
Were you trying to cooperate?
In every way.
Were you polite with them?
Very.
And when she said that, we just have to do it, you said, just like we did yesterday.
Yes.
And then you said normal protocol.
Yes.
Is that what she had said the day before?
What do you mean?
Normal protocol.
Yes.
Had she said the same word? You said normal protocol to her.
I was reiterating to her what she had said to me the day before.
Y'all in the chat are killing me right now. Some of y'all.
So
are
she
getting
read the
so
Miranda
mad.
rights to you,
Except number 9.
except number 9. She read the rights and then she said, do you understand what I've just read to you? And you agreed that you had.
Yes.
But you were not read Having these rights in mind, do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you. Do you agree to speak to us now?
I was never asked that.
Yeah, right. That's in summary. That's what I'm getting out of it. You called them. Like, see, she thinks that she's smarter than everybody. So she couldn't wait for the game.
The way that
I've
she
seen this before in true crime.
acted,
She
the
couldn't
things
wait
that
for
she
the
said.
game of playing chess with the detective. The cat and
The fact
mouse.
that they had your phone.
Because they watched too many fucking movies.
Did you get the impression you were not getting your phone back if you didn't answer the questions?
Sustained.
She was in custody?
I think
That's
you're
been
trying to
conceded
trick me.
by the state. In their response,
I'm
there
gonna
was a
come down
custodial
here.
interrogation.
Okay, but she wasn't aware of it. She wasn't aware
Try
she
to
was
get
in
ahead
custody.
of it.
What does her subjective perception matter?
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed small space.
What?
That all goes to whether or not.
She was being questioned by two lead detectives,
Did she
homicide detectives.
volunteer?
One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
Right.
Well, I know some of the factors are whether or not the interrogation
I don't know what that
actually
means.
happens in
All
a
I
police
know
station
is
or not, or whether it
sounds like
happens
a police
outside a police
station to
station.
me.
So just that environment alone.
That goes to whether or not it was a custodial interrogation. I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not, based on
Subjectivity matter.
Excuse me, based on
Subjectivity matter under the case law.
based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
Right.
I believe it's relevant.
Objection's overruled. I'm sorry, the objection sustained. I apologize.
I
Did you
mean,
understand you were not going to get your phone back until you answered their questions?
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Sustained.
yeah. Nobody wants to know how you feel.
Ma'am, that day, you came to the sheriff's department to get your phone?
Yes,
Did you know that you were going to be placed in custody?
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Overruled.
Were you there answering her questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
Cross-examination. This should be great.
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct? You consumed no alcohol in your home that morning, correct? So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
One more time, please.
Nice.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
Meaning everything we just heard means shit.
Then.
Did alcohol affect my conversation with her?
Did it affect
There's a
the
jury
memory
instruction
of the
that
conversation?
says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect
Oh, man.
my answer?
It's like watching Colin Albert on a stand.
I don't.
Okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she doesn't know what.
She admitted that she was under the influence of alcohol. Does alcohol not affect your memory? How are we supposed to take
The
your
court does not
testimony
entertain
here
speaking
seriously?
objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I know that she had said she didn't know what.
What are the legal grounds of your objection?
I'll withdraw.
All right, you may proceed.
All right. And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct? Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
I would object to that.
I
I'm
mean,
not understanding the question.
this is
Mr. J.
This is slick.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that
I love what he's doing right
her
here.
credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Copesel's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided
Why
to
else
law
would she want
enforcement
to
in
suppress?
State's Exhibit 1. And therefore, she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out, so that she is
So
not
that
going
she
to be
can say something
cross-examined and
else.
impeached with it, so that she can testify the way that she testified this afternoon.
Wow, dude. This dude is calling bullshit.
I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 years on the low end. I agree with all that. We just got through at the jail meeting with the state's expert who evaluated Sarah Boone.
Yeah, look at the blinking. She's blinking, man.
It wasn't
Look at that.
He
Trying
can't
to cool down those eyes because you know they're on fire right now.
evaluation, and he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what he's saying here.
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for
All
me
I'm doing is calling her out
extrinsically,
on her bullshit.
impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
There you
You
go.
gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, Would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted?
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back
Nice.
to council's table.
So he just got her
While
to
she's in the
admit on the
process of
stand.
returning to council's table, anything else further from an evidence or testimony perspective from your side of the?
He just got her to admit on the stand that she wants those statements redacted and those statements excluded, so that she can change what she said. She could just change her story. Basically, she filed a motion to be able to fucking be set up to change her story, and the jury is none the wiser. And the prosecutor was like, bullshit. No, dude. No, dude. We're not doing that.
Judge, my understanding of the law regarding Miranda, first issue is, was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And I think under the totality of the circumstances, the court has to.
In hindsight,
determine
this
whether
hearing is a
freely,
big waste of
voluntarily,
fucking time. It's
knowingly
more stalling, you know?
Given under the circumstances.
They had to know they would never get that.
Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him. The law allows law enforcement at that stage to use deception, to lie, to trick.
This guy has the personality of a turnip.
We found the murder weapon. It's got your DNA on it. Your co-defendant has come in here and confessed and implicated you. All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, it can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick. That right is fundamental. You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be.
He's trying to be dramatic,
will
but
and a choice.
He's failing.
And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish law enforcement.
Punish
to
law
correct
enforcement.
that type of misuse behavior.
Punish law
It's illegal
enforcement for this.
So you got Detective Kopsel on the one hand.
Hottie.
I got to read your rights. And you have a right to remain silent. But within a minute before, the detective is telling Sarah Boone, we have to do this. we have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that that should be allowed or is allowed. There's nowhere in the law that that should be allowed. It's actually illegal to tell a suspect, we have to talk to you. We just have to.
Shut up!
Before reading Miranda.
Oh my God, I don't care!
That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened. But that's the implication this detective gave Sarah Boone. It taints the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
But the statement of we have to read you the rights was made before we have to talk to you. So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses.
Get the fuck out of here.
A traumatic event, she lost her boyfriend. I'm coming to get my phone. I've been tricked into coming up here to get my phone. And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying we have to talk to you. We just need to do it. And then she reads the rights. Right there within a few seconds of each other. That's improper, it's illegal, it's coercive. It forces this not to be a valid
That's
waiver
not what
of her
happened,
rights.
though.
Under that
That's
circumstance.
not what happened.
Coupled with the fact that she came down under false pretenses.
He just keeps repeating himself. This guy is the worst trial lawyer ever.
Coupled with the fact she doesn't have the 9th question. If you think about it, okay, you got a right to remain silent, you got a right to a lawyer, those 3 or 4 questions, and then, do you understand what I've just read to you?
What the fuck are you talking about?
But then Detective Copsell goes right into questioning. Once Sarah says, yes, I understand, it's an acquiesce to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us? That is the time of free choice. That is the time of decision for Sarah to be given that opportunity. But the way I understand, Detective Copsell had the autopsy. She had the blunt force trauma. Those were not questioned. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before. So sure, any detective worth their salt would want a statement. She'd already said we had probable cause. We'd already made our mind up that we were going to arrest her. If she didn't come, they were going to go get her. If she came and said, I want to enjoy my rights, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them that she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Any response?
Judge, the United States Supreme Court has said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2 hour and 6 minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read.
You're entitled to shit.
And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th. They are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Kupsel's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Kupsel's, and of course she has a bias.
This guy's gonna own the jury, dude. He's just gonna fucking
has no motivation to not tell the truth about.
You're just gonna sit on
whether
his
she
lap
used
the whole
deception to bring the
goddamn trial.
defendant down to the police station, because that's perfectly acceptable. So we're asking you for the reasons that we stated in our multiple responses to their multiple amended motions to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
No, Judge.
All right. Has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed, but I'll be here working.
Judge, for the record, there's 2 exhibits that I tried to introduce. They will be admitted into the record.
Yes, of course. They were pre-marked. Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. State, what, if any, positions do you have with regard to the restraints?
Again, we've already decided that issue. I don't know that there's been any new allegations
That's what I
alleged
thought.
in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already, and unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Response.
And Judge, I just want clarification.
God,
but,
this guy's
you know,
got a
she's
fucking-
here today and she's in
Everything.
handcuffs, so she has difficulty writing. She has.
Let me just interject for 1 second. She will be hands-free.
Okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this
Yes, sir.
courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature. She has a
Let's
fundamental
just give her a
right to
bunch of
fair trial.
ideas.
She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger. And people automatically will take that to heart, and it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table.
Let's
I
just
don't know
give
if we
her a
switch it.
plan.
Does the prosecutor
There's,
go?
there's a door over
that's your
here,
table, sir.
Sarah. There's a door over
Closest
there.
to the
There's a
jury.
door over there.
So she'll be sitting here with the other 2 lawyers and I. And the only time they're going to see her walk in and out is she's always going to be in the courtroom.
They're never going to
first.
see her walk in and out.
So the only time is when she testifies. So I guess I don't know if you have leg restraints that she can wear and walk, but we believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny.
Yeah,
As she's walking from the defense table.
He's trying to
the witness
argue
stand
her
to
leg
testify on her own
restraints being
behalf.
removed during
But I don't
trial.
think it's necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and
I agree with
assume
him
the table's
actually
going to
on
stay
this.
here.
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. You know,
I mean,
there are
that's not a very
times
good
when
argument, but
criminal defendants are in a trial and they misbehave.
But I agree
in
with
the
him.
middle of the trial, so they have to be restrained. But Sarah Boone,
That
as
hasn't
far as
happened
I've been
yet.
involved, and I
Exactly.
think prior to that time, has always been polite and cooperative. And she understands the importance of behaving. And I have every intent that she will comply with the court's directive and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Anything further as to that issue?
I don't believe that's case law authority on the issue.
Yeah, like I feel like a
All right,
stun
thank you very
gun
much.
belt is probably fair.
With regard to
Yeah,
your
like they
request
did with
for
Daryl
clothing
Brooks.
in that,
I
you can
feel like
certainly
that's
go to
fair.
the jail and provide, have whoever it is that you want to
Right.
meet with her in the
One of
meeting
those
area
deals.
to get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. So your motion will be granted with regard to the clothing. You'll have to address with the jail, having a person come in there to take her measurements. They may have to be with you, counselor, in order to facilitate that. But the clothing will have to be dropped off at the jail, and it will be transported with her in the morning each day of trial. With regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair, cosmetics, civilian clothing without restraints for trial. Just the arguments in there.
And the Estelle case that you spoke to being dressed out in a prison garb. It doesn't really address a prison guard in shackles. It doesn't address any beautification or anything along those lines.
I just think it's just part of a fair trial.
The other problem is it's contraband.
It's part of fair trial.
That stuff's not even purchasable at the commissary at the jail, any makeup or anything along those lines.
Well, I'm gonna have the two paralegals here. I say the paralegals. One's a lawyer now, and the other is a consultant. But they're females, and they can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
Can she be allowed? Can the two females on the team can they be allowed to apply some type of makeup to Ms. Boone?
State?
We don't have any dog in this fight. I've never heard of it happening. That doesn't mean it's not permissible, but
if you want to try to do it here in the courtroom, that's fine. But be advised that, when we start court, we start court. So, and I intend on starting it at 9 o'clock every morning. So I'll have pleas every
give her a
morning.
little compact and I guess, I don't know.
plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter. So your motion will be granted with regard to
Right, like the jury doesn't
clothing.
have to
You can
see
perhaps
her
only
like
attend,
a
travel to the
psycho
jail
with
you,
a suitcase.
Mr. Owens,
you
to
know?
take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secured areas. But if you want to attempt to have members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request to removal of the leg restraints. But the hand restraints will be removed.
Yeah, I mean,
it falls under the same analysis.
It needs to be done in the courtroom.
Yes, sir.
I mean, she needs every
Then
chance
the
she can
last
get,
item
bro. Like,
teed up for today is the. Oh, I'm sorry. Yes. Yes.
I mean, she's not exactly.
So corrections in the Orange County Sheriff's Office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband. They don't know what's placed on her person. That's the concern.
There's just going to be some facial makeup.
I understand, but
I love this whole
DOC
ordeal over.
and sheriff's officers tell me they can't do it because of the concerns that were just outlined.
So
after
now
she's returned to the.
Oh. So what if she washes her face?
All right. You'll get an order with regard to the restraints no later than tomorrow. Moving now to the state's request for protective order. I've reviewed that. I need more. I need to understand what
Thank
you're
you, Special
looking
K.
at, Mr. Owens, with regard to these custodians and supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
And remember, Special K, venting is just a made-up word designed to excuse complaining. The more you know.
It was filed on Monday, forgive me. I had emailed y'all and said that it would be addressed today.
That was relating to me subpoenaing the, and listing the, I think it was the.
It's the third amended witness list lists certain people as witnesses: custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor for the Office of the State Attorney, and misdemeanor supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's work product or opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
Judge, as you know, we have filed our notice of intent for battered spouse syndrome in conjunction with self-defense. And we have listed and plan to introduce the fact that George Torres had been arrested, I think, 3 or 4 times prior to this event. And I think on 3 of those cases, the case was dismissed.
Thank you, Kayla Jones.
Mr. Torres. And it's going to come out.
Probably
that
right.
Sarah Boone had requested the charges to be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of bail and then get the charges dismissed as a battered spouse. That's a common theme. So ultimately, the jury is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether.
Wait, is he arguing that she bailed him out?
Yes, they are.
And that means that she's a battered
victim wants.
victim?
They are to consider their request, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons?
That.
How would that not be protected by work product?
Well,
As to whether or not it was a decision.
If it comes out that she went down there and requested the charges be dropped and they were dropped, then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charges to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't have to drop cases even if a victim claims they do. So just that decision by the state attorney to drop it was their decision. They considered the victims, but it was their decision to drop it and their power and authority to do so, not the victim's authority.
So what is that? What are you bringing it up for?
Response.
I'm lost.
Judge, that's opinion work product. That is absolutely protected. I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we are moving to quash those.
Oh, I love you too, buddy.
Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And if they want to get public records about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. I mean, the state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that they don't even have this evidence. We got dropped last Friday, the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases.
Well,
and
that's her only play.
It's up to defendant if she wants to come in and say, yeah, I asked to get these cases
Because she's
dropped.
on video
that
saying,
evidence coming in
this is
anyways
for all the
through
times you hit
extraction.
me.
She is
It's
immediately
the only chance she has, but
working
it's
to bail
bullshit.
the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is going to come in, but it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument.
So she's texting him, telling him to drop charges against her. I was just gonna say, I think they're both assholes. I feel like the two of them were shitty to each other. That's what I think.
No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in a case. Not why we chose to drop 3 cases against George Torres, but they have the ultimate authority. The victim does not control the case. The state attorney.
Yeah, that's what I'm thinking. Very toxic, very
Written order on the
dysfunctional.
motion protective order for tomorrow.
That's what I'm
tomorrow
thinking.
as well. Anything else, state, we need to address?
It appears, and again, been conducting motions all afternoon. It appears that we are set to allow the defense to depose our battered spouse syndrome expert at 10 a.m. tomorrow. Yeah. And that will be done virtually.
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
That's set at 3 p.m.
Okay, that's still set at 3 p.m.
Yes, there will likely be a pending motion to strike if his testimony is duplicative Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here or is that taking place in South Florida? Virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
Okay. All right.
Judge, and then on Dr. Brannon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10. Paul's expert works by Zoom. And we did talk about that at the jail, trying to schedule something for tomorrow. So she just evaluated Sarah Boone from noon to 2, and then I'm going to take her deposition at 10 tomorrow morning by Zoom. And then we're taking Dr. Brannon's deposition. If they file some type of motion about that, then of course I'm going to respond. We're going to need to have a hearing on that.
Okay. Go ahead, I'm sorry.
Those 2 things are the only 2 things that I believe we have left prior to jury selection on Monday.
Okay. If any motions are filed by anyone moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, state if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the potential penalties, everybody's on the same page as to what those are. Okay?
Yes. And if y'all could send me that, I'll go out to the jail. I'm going to be here.
If you could favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance.
Yes, and then we're going to be filing a motion in limine to exclude the battered spouse syndrome testimony that will need to be addressed.
Wow.
Just waiting to
The
see
puns.
how the depositions pan out tomorrow.
Unzipping the
truth.
truth.
This afternoon, it's the state's position that we're going to need to file a motion.
Okay. All right. Appreciate it. All right. Thank you all very much. We'll address scheduling of any motions on Monday. And it may be a circumstance where, as the court had identified earlier, that we're just going to be looking at cause issues and what people may know about this case. That'll be happening before we turn it over to you all, which would include, Mr. Owens, your opportunity to voir dire on any defenses that may be being raised in this case.
Voir dire.
We may get a panel.
I thought it was
ask them to
voir
come back later in the
dire.
week so that we can have those motions after we get that panel of 50, once we deal with all the cost challenges. Okay? All right. Thank you all very much. We'll see you Monday morning at 9 a.m. Court's in recess. Thank you.
Monday morning, 9 a.m. All right. So that's that, man. What the fuck dude? That lawyer was reaching, dude. Let me get this set up. We'll talk a little bit about this. We're still gonna hang out a little bit, guys. We're still gonna hang out a little bit. Hold on, because we still got to go over. We got to go over this real quick. So, yeah, man. So they filed a motion. The defense filed a motion. Sarah Boone's defense filed a motion to have certain statements excluded from the evidence. And clearly, the whole point of this was so that she could change her story on the stand, and the jury would be none the wiser, right? Which, all you have to do is just kind of point that out as a prosecutor and go, Your Honor, like, what? So, I got to give it to this lawyer for trying. The problem is that he's not convincing at all. This judge seems to be a wall of stone. A wall of stone. And he just seems to and he's fair. He's fair. He overruled a fair amount of objections. He sustained a fair amount of objections from both sides. He was listening, but once it got to a certain point where it's just like, okay, what the fuck is the relevance of this shit? What do you think you're pulling here? So that was fun to watch. This trial is going to be bananas because it seems like this prosecutor is just going to steamroll over this attorney. This is her ninth lawyer, dude. Like, this is the bottom of the barrel, bro. Like, this is beyond the bottom of the barrel. This is like scraping, bro. Like, this is scraping. This is, you know what this is, dude? This is not fucking like, back in the day when you were smoking weed out of a fucking metal pipe, and you had to kind of stir it for a second, This is beyond that. This is scraping the resin from it. This is what this guy is. This is the resin of defense attorneys for Sarah Boone. That's all that is. So it's going to be interesting to watch because he's you know what he is? He's fucking bong water, dude. This guy is bong water. And he's going to stink up the whole goddamn courtroom. And it's just going to be entertaining to watch. It's this is not going to work out well for the defense at all. But he's trying, because the thing is there's no case. But also the fact that, I get what he's doing. He's trying to find any loophole, any technicality that he can, anything that he can exploit. Great. The problem is that works for lawyers who can actually present it. That works for lawyers who can talk. This guy can't talk. So this isn't going to work out well for Sarah Boone at all. I'm really, 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 really interested to see what goes on here. Now we're going to move on because we're already hitting 3 hours, but we're going to keep trucking. I fed Clubber. I might have to step away and take him outside, maybe not, I don't know. But he's eating real good because I'm going back to the gym, and I forgot that I had steaks in the freezer from before I even went on vacation, so I thawed those bitches out, and I cooked them both because my eyes were bigger than my stomach, and then like so Clover basically got a whole goddamn steak with his food, and he's like loving life right now. But he's a good boy. He deserves it. So we're going to move on to the Brian Walshe thing. Now, the Brian Walshe thing, folks, I'm going to be following this case very, very, very closely. I think we all should be following this case very, very closely. Those of us who are following the Karen Reed case, since I don't have Karen Reed tagged here, I'm not going to have a whole lot of people watching here, but make sure to let people know. This is going to be very important to watch because we're going to see the Commonwealth of Massachusetts, Norfolk County, the Norfolk County DA's office will be prosecuting Brian Walshe. And Michael Proctor was also the lead investigator in this case. And Auntie Bev is the judge. And most of the evidence that is going to be used against Brian Walshe here, and I believe him to be 100% guilty. This is a man who murdered his wife, and he Googled all kinds of things about, how to get rid of a body, so on and so forth. A lot of really, really dark things. He Googled these things. This dude is I believe to be 100% guilty, and the Google searches were recovered by none other than Celebrite software. The Google data, the everything is recovered using Celebrite software, and now it's going to be interesting to me to see the very same DA's office, the very same Commonwealth try to convince a jury how credible Celebrite is after they tried to discredit Celebrite during the Karen Reed trial. That's going to be very interesting. And I'm referring to obviously the 2:27 a.m. How long to die in cold Google search from Jen McCabe. Now, people, this is going to be very, very, very interesting because I feel like this defense attorney, if this defense attorney is worth half a shit, he's going to bring that up. He's going to say, well, did you or did you not try to discredit the credibility? Did you not try to discredit the accuracy of Celebrite, the integrity of Celebrite, and how reliable it is? Discredit the reliability of Celebrite. Did you or did you not try to do that in the Karen Reed trial? I mean, the defense would be foolish not to do that. So I don't know exactly what this is for, this motion is for, but or this hearing is for, but we're going to check it out. And it's a short one. It's only like 17 minutes long. Of course, movie clips are covered. Maybe not. I mean, we'll see, but Joe, Flipperhead, yo. Amazing, dude. I really appreciate the love, dude. Seriously. You guys subscribe to Joe Flipperhead. Joe Flipperhead. No, that's not. Yeah, I know, right? The courtroom. It's the same courthouse, but I'm not sure if it's the same room. I mean, I'm assuming it is because it's Bev's, you know. Yeah, Scott knows. Yeah, this is gonna be an anti-Bev, dude. I gotta fast forward through this shit. This shit isn't live. Hello, how's everybody doing? Who's this guy? Oh yeah, this guy was in the courtroom. Yeah, this is the guy that shushed me when when Kevin Reddington was talking to me. I was like, dude, you're gonna get me kicked out of here, bro. Look, there she is. Oh my god. Dude, what's crazy about this is like we're gonna follow this, but I'm gonna be rooting for the Commonwealth. This guy, I believe, is fucking guilty. He belongs in prison. You know what I mean? So, like, ironically, I'm gonna be rooting for the Commonwealth here. You know, like, I want to see this guy go to prison. Like, this dude is bad news, man. So this is crazy because here I am, and this is it's an infuriating thought when you think about it, because I'm rooting for a system that I already know to be corrupt. That's a hell of a fucking dilemma in integrity to have, because I believe this man to be guilty and I want him to go to prison. But this system that's tasked with the responsibility of prosecuting and convicting him are corrupt, without a doubt. I even believe the judge to be corrupt. This is insane. I know, buddy. You ate all your food. You're just gonna have to wait. Let me fast forward through this, okay, buddy? Like, when is this hearing starting? Here we go. Oh, look at this guy.
Boo! You suck!
Good afternoon, Your Honor. Good afternoon, everyone. Kelly Portes on behalf of Mr. Walshe. Good afternoon, Ms. Porges. Good afternoon, Your Honor. Larry Tipton from Mr. Walshe. Good afternoon, Mr. Tipton. Good afternoon, Mr. Walshe. Good afternoon. Mr. Walshe, you can
Good afternoon. Bro.
All right. So, Mr. Tipton, I've read your materials that it seems like maybe the Commonwealth gave you in the last week from when the motion was filed for
I know, buddy. You're gonna have to wait a little bit. Okay, you'll be all right.
Well, I don't want to speak for the Commonwealth, and I want to make sure that Mr. Walsh understands, because I just told him something different in Paco.
Okay.
I think based on the representations of the Commonwealth, both in its communications yesterday and then this today, there's a lot of discovery forthcoming, some of which addresses some of our requests, some of which we don't. So I think it's a waste of our time to argue this extensive motion and memorandum of law. And I was going to explain why we filed such a detailed memorandum of law, but I don't think I need to waste the court's time with that. So I think what we're suggesting is, at least what we're suggesting, is that we come back on December 2nd, having had a chance to review what's coming, and then
Narrow the motion as to what you might still need. All right. I'm sure that's fine. If you determine that some of what you're requesting is Rule 17, do you anticipate being able to file them that day or not? I'm not telling you you have to. I'm just.
Well, I can tell the court that we're certainly looking at our request to see if they require Rule 17. And I'll just very briefly say that in our memorandum, when we address internal affairs, we are suggesting that right now, under the present facts and circumstances, that we argue in the memorandum that a Rule 17, even for internal affairs, isn't necessary given where we are today. And the court may certainly disagree, and we said in our memorandum, if the court orders us to follow Weyness, we will. But if we know that a Rule 17 would be required, I would anticipate we would bring it with us.
And it's in not necessarily regarding the internal affairs, but other things you were looking for. I thought were probably a little bit more.
This is gonna be a clusterfuck.
So that's what I mean, not those. I understand litigating whether.
For Karen Reed supporters, this is gonna be a clusterfuck.
Rule 17 or Rule 14. I can see that maybe we will have to have that discussion, but the others that I think maybe after you look at what you have, you might think is Rule 17. So on those, do you anticipate you might be able to file them by then, or it's too early to tell?
I think it's too early to tell.
Okay. How about if you can, you will?
That's absolutely right.
Okay. All right. Does that make sense, Mr. Connor?
Perfect sense, Your Honor.
12-2 works for me. Jimmy, does it work for you?
It does.
Okay. Do you want Mr. Walsh brought in that day?
I think we should issue a Hague, and then Mr. Walsh and all of us will talk and see if he needs to be brought in. But if we're going to have a hearing, yes, I will.
Sure. So we'll
No, this is not Reddington's
But if you
case.
don't want to come, let us know. And I think that.
And just finally, and I don't want to interrupt another Commonwealth, but the Commonwealth has filed a motion for protective order for some of this stuff. Right now, the status of that, we don't object to the protective order. Our understanding is that we can share the information with Mr. Walsh, but we're not going to give him hard copies of anything just yet. And we don't object to the redactions that appear today. We just want to review what we have, and then we'll come back. That's our understanding of the protective order. That's our joint understanding.
Okay. That's what I would order anyway at this point. So, all right. So I'll allow them to call a motion for protective order.
I'll allow it.
All right. We'll see you December 1st.
December 2nd.
Second, that's what I thought I heard. Yeah, December 2nd, Monday, December 2nd.
All right. Thank you, Mom.
Thank you, Your Honor. Thank you. Thank you.
Jimmy.
He looks awfully confident, doesn't he? For a guy in shackles. He looks awfully confident. I wonder why that is. And his lawyers seem to be on point. Yeah, like what is this? Okay. All right. All right. So it's already been like 3 hours, 15 minutes. Man, you guys have no idea how much it means to me. You diehards that were here to this afternoon and hanging out with me, man. It really means a lot. I know attorney Melanie Little was live as well, and she's an attorney, and I would encourage you to watch her lives at least on a replay, because she's absolutely fantastic, and she's going to give you some insight from experience that I would not ever be able to provide you. But if you're just looking to hang out with somebody and watch this stuff, man, I'm really grateful for those of you who choose to do so here. It really means a lot. So you guys are really, really dope, man, and it means a lot. And thank you guys. Make sure to hit the like for me. Make sure to subscribe if you're not subscribed already, and make sure to share this stuff too, man. Recommend me to your friends. And I would love to hit 40,000 subs by New Year's. That would be fucking fantastic. So it's always good to have something to try to strive for. So I really appreciate you guys hanging out with me this afternoon. This is absolutely fantastic. And yeah, man, Clubber needs to go. So you guys are absolutely amazing. I love you guys very much, and we will do this again very soon, my friends.